All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Before we get started, I want to welcome the folks from 71st High School in Fayetteville, students, teachers, administrators, whomever may be here with us. We welcome you. Thank you for attending your North Carolina Supreme Court. Our next case is Happel versus Guilford County Board of Education et al., and we will hear from the appellant.
Good afternoon, Your Honors, and may it please the Court. I'm Stephen Walker. I represent the plaintiffs' appellants in this matter, Emily Happel and Tanner Smith. The issue is whether Congress intended to provide complete immunity to a local government entity and a medical society for administering a COVID vaccine to a 14-year-old without the 14-year-old's consent or the consent of his parent. Tanner was 14 years old at the time relevant to this case. He was a football player at Western Guilford High School, which is a Guilford County public school. On August 14th, 2021, he was informed by a letter from the school system that there was a COVID outbreak cluster among the football team, and that he would need to be tested before he could continue participating in team activities. The letter informed Tanner that he would be tested on August 20th, 2021, between 2 and 6 p.m. at Northwest Guilford High School, and that the Old North State Medical Society would be conducting the testing. His stepfather drove him to the testing site on August 20th, and Tanner went into the facility. He was given a form to fill out, and he thought it was a form for testing. What Tanner didn't know is that there was a vaccine clinic being held in the same location as the testing site. It's unclear as to why a testing clinic, where people who think they might be sick go to see if they're sick, would be held at the same place as a vaccine site where people who don't think they're sick think that they can go and not become sick, why you would hold those at the same location, but that's what happened here. There was a flyer that promoted the clinic, said it was being put on by Old North State Medical Society and Guilford County Schools. It also stated this, I quote from that flyer, "Students aged 12 through 17 must have their parent or guardian sign the consent form and bring the completed form to the vaccination site." That was the requirements on the flyer. Tanner was shown to a seat, and the workers attempted to contact his mother, Emily. They were unsuccessful in doing so. One of the workers then instructed the other to just give it to him anyway. Tanner then told the workers he did not want a vaccine and that he was here for a test. And despite failing to get parental consent or Tanner's consent, they administered a dose of the Pfizer COVID-19 vaccine to Tanner. The PrEP Act is what this is all about. That's what this case is about as far as this court's concerned, because this is what you granted review on. This is what you allowed the PDR on, was on the PrEP Act question. And the PrEP Act is admittedly broad in its immunity, but it is not unlimited in its immunity. The PrEP Act appears on its face to be very broad in terms of immunity. It speaks of all claims, that a covered person is immune from all claims. Now, the PrEP Act is activated when it's activated by the Secretary of Health and Human Services. It's not contested in this case that the PrEP Act was activated. The PrEP Act applies. It applies to the case. It's not contested that the Pfizer COVID-19 shot was emergency use authorized, because it was. And it's not contested, at least for purposes of this appeal, that Old North State Medical Society and the Guilford County Board of Education are covered persons under the PrEP Act. But it is contested that the immunity is not so broad as to totally immunize defendants from any liability for battery and state constitutional claims. This decision is for the courts. The Supreme Court of the United States, in their case Loper Bright versus Raimundo, makes it clear that deference doesn't have to be given to an administrative agency's interpretation. And that being said, even the United States Secretary of HHS stated in the emergency declaration activating the PrEP Act, this quote, "In each case, whether immunity is applicable will depend on the particular facts and circumstances." If it was simply just all claims, no matter what they are, that doesn't make a lot of sense to put in your declaration that the immunity provisions will depend on the particular facts and circumstances. As the Court of Appeals rightly noted, the conduct alleged in this case is egregious. And that's what the Court of Appeals said. They said it is egregious. And those are the facts that are particular to this case. Those are the circumstances that are particular to this case.
I'd like to ask you about the definition of loss in the PrEP Act. It does use some broad language to say any type of loss, but then it gives some examples. And they include death, physical, mental, or emotional injury, illness, disability, or condition. And what strikes me about the examples is that they seem to be the kinds of things that you would have in tort claims. So how broadly should we read the term loss? Should we read it as, well, obviously you don't agree with the other side, but should we read it to mean the kind of loss that you see in tort claims? And is that a basis for our decision? That is, that the injury in this case, or the if you will, the loss complained of simply isn't within the scope of the PrEP Act?
I think that is, in a way, what I'm arguing. And I think that's a very good point, because when you look at what Congress was trying to do in the PrEP Act, it was really, in times of emergencies, Congress sought to open the door to unapproved treatments, right? So we've got an emergency. COVID's going on, or it's been, I think, in H1N1, I think it was put in. There were some other times that the PrEP Act has been activated. And what Congress wanted to do is Congress wanted to say, okay, if you have an adverse effect, or if you are injured in some way, because testing time is short, we've got to get this treatment out. We're trying to stop an emergency from happening. It was for those kind of things that Congress was concerned about. Loss, as far as, you know, the death and the injury and things like that. That's what Congress was really concerned about. They wanted to relieve liability from drug manufacturers and medical professionals who are trying to combat an emergency. That's really what they were trying to do. And I think you can look at the emergency use authorization statute, and you can see that Congress didn't want to throw informed consent out the window. That it's narrower than what is being argued by the other side in this case. They did not want to throw that out the window, because when you are applying for an emergency use authorization, one of the things that you have to have as a condition is appropriate conditions designed to ensure that individuals to whom the product is administered are informed of the option to accept or refuse administration of the product. And so Congress said, even with an emergency use, we're going to require some kind of consent. And that's what this case is about, is now you've got someone who was given the vaccine. They were given an emergency use vaccine, a 14-year-old who was given that without parental consent. And Congress said, if we're going to do this, we still have to have some kind of consent. There has to be some kind of consent that's going to happen here. And it impacts both his rights to his personal autonomy and his personal liberty, and then also his mother's right to direct the upbringing of her child and to make those kinds of decisions. What Congress did in the PrEP Act, it makes sense when you interpret it that way. When you interpret it that we're trying to stop lawsuits against drug manufacturers and against covered people who are trying to help in a situation, right? Who's trying to help in an emergency, not when they do something like this, which is to give medical treatment without any kind of consent. To say that Congress was authorizing unconsented to treatment at the whim of a healthcare worker on an underage patient without parental consent, that makes no sense. It makes no sense. In fact, I would say it is an absurd result. In our General Assembly, they recognized that that would be something absurd, so they passed a law. General Statute 90-21.5, subsection A1, said before anybody can give someone under 18 an emergency use authorization treatment, that they need written consent from the parent. And I don't believe it's disputed at all that that law was in effect at the time that this happened. And so the General Assembly has said, this is a no-no. Now, what the General Assembly did, of course, makes sense. I noted in my brief that these claims, the battery claim and state constitutional violations, would have been made regardless of whether this was a COVID-19 vaccine or not. The claims are not because it was a COVID-19 vaccine, they just happen to be. They just happen to be. Other than the PrEP Act, I believe liability would be clear in this case, other than the argument that there is immunity under the PrEP Act. I know there are other cases that have interpreted the PrEP Act. They're from other states and other jurisdictions, and they've ruled that immunity applies. Some of them were for accidental things. Some of them were for lack of treatment. And they've ruled that the PrEP Act did apply and provided immunity. But those cases are not binding on this court. And quite frankly, the other courts got it wrong. And this court can get it right. The fundamental right of a parent to the care and control of the upbringing of her child and Tanner's rights to individual liberty are older than the PrEP Act. In fact, they're older than the Constitution of North Carolina, and they're older than the Constitution of the United States. They are fundamental rights. Fundamental rights that cannot be removed by an act of Congress. A right without a remedy is not a right at all. And that's what I'm here asking for today, is a remedy. Because a right without a remedy is not a right at all. I believe the North Carolina Values Institute brief laid it out well. I know they focused on federal issues there, which are not before the court right now. But the whole idea of the fundamental nature of Tanner's individual liberty rights and his mother's rights to control the upbringing of her child are well set out there, and you can see the historical nature of those. Interpreting the PrEP Act this broadly would be an absurdity. A person could be brought into a medical office under a false pretense and being given a vaccine without consent, maybe not even being told what it was. And when they find out what it was, well, we've got immunity. We've got immunity under the PrEP Act. Even though we lied to you or we didn't tell you what it was, or we brought you in under some kind of false pretense. I don't see how you can argue that under the Court of Appeals interpretation that someone who did not want the shot couldn't be held down and given it with no liability for the administrator of the shot. Under that broad of an interpretation, that could be the case. And when you talk of absurdities in the law, it isn't whether the law is absurd, it's whether it leads to an absurd result. I would imagine that there are a few in America that would say you should be able to give a shot to anybody you want, anytime you want, in whatever manner you want, without consent, and that they should be totally shielded from liability. But that's the argument. That's the argument that was being made, and that's the decision that the Court of Appeals made. I think mankind and womankind would see this conduct as egregious and one that demands accountability. This court can avoid a constitutional question, which I know courts generally want to avoid constitutional questions if they can. I think the Children's Health Defense amicus brief did a good job of setting out why the PrEP Act may have some Commerce Clause issues if this immunity applies, and I think we can punt that issue if you rule correctly, as I'm arguing on the immunity issue. This court should hold defendants do not have immunity under the PrEP Act for battery arising from lack of consent, nor for the state constitutional violations. Similarly, there's no preemption in this case. The defendants appear to agree with the idea that there's no complete preemption of state law that would force any case that the PREP Act's alleged in to be brought up into federal court as opposed into state court. The holdings of the federal courts on these issues has been uniform, that the Act does not completely preempt claims. The Saldana case that I cited in my brief from the Ninth Circuit is instructive, and the Supreme Court of the United States denied cert on that. That court held that the PREP Act was not a comprehensive statutory scheme that would totally supplant state law claims. So what the defendants argue here is that the preemption serves not so much as a complete preemption that would get you totally out of state court and make you be only in federal court or only be on federal claims, but that the preemption serves to extinguish the state law claims. In effect, their argument is that the immunity provision also preempts the claims and that it extinguishes the claims. Thus, under their argument, state constitutional and state law claims would be remanded by federal courts to state courts just so that the state courts could dismiss them as being preempted by federal law. And that leads to kind of an absurd result. In practical effect, the parties seem to agree that if immunity applies, the case should be dismissed. If immunity does not apply, then the case should proceed. And that's really what the issue is more about the immunity than it is about the preemption. Finally, I want to note that the court did not grant review or allow review on the additional matters raised as alternatives for the court to affirm in their brief, in the defendant's brief. Those issues were not decided by the Court of Appeals, and if the court reverses the Court of Appeals on the immunity issue and the preemption issue under the PREP Act, the better course would be to remand the case to the Court of Appeals and let the Court of Appeals wrestle with those issues first before it comes to this court, if it does. And that would be the best way to do that. This court has already decided that those matters not reached by the Court of Appeals are not properly before the court. Congress did not intend to provide immunity for the egregious acts alleged in this case, and this court should so hold. I would ask that you reverse the decision of the Court of Appeals. I'm happy to answer any questions.
Thank you, counsel.
Thank you.
Hear from the appellee.
Good afternoon, Mr. Chief Justice. May it please the court. Steve Rawson of Barrington Smith on behalf of the defendants today. Just 2 months ago, this court reaffirmed what it has said many times. We begin with the text of the statute, and if that text is clear and unambiguous, we conclude that the legislature intended the statute to be implemented according to its terms. This case presents just one more application of that bedrock principle, which the Court of Appeals faithfully applied even as it was clearly uncomfortable with the policy consequences of doing so. Other courts around the country, from Kansas to Wyoming, from Vermont to Nevada, have done the same, and we would ask this court to do so as well. Now, before diving into the statutory text here, I would like to address some of the scope of what we're looking at here in terms of the briefs. And as counsel noted earlier, the pleadings on their face show that the school system and the medical society had a parental consent requirement in place. The pleadings on their face show that the clinic workers initially tried to reach out to the parent to get that consent. And it was only a departure when one clinic worker overstepped their bounds and administered the vaccine over the verbal statement of the student.
Under your theory, why does that matter? Why do those facts matter?
The facts matter here, Your Honor, because of the scope of this case, that this court does not need to decide the outer limits of the PREP Act today.
But don't we have to consider that? For example, if we rule broadly, don't we open up the possibility that someone, for reasons of their own, under these circumstances, could go around and involuntarily provide this vaccine randomly to whomever they chose, and there would be no consequences?
So 2 responses to that, Your Honor. First is no consequences, I think, is an overstatement. It is no civil liability, but there is no protection for an employee who goes outside of the scope of their employment and administers a vaccine without consent. They can be fired.
Well, And is that what happened here? Did they go outside the scope of their employment?
In terms of, they certainly went outside the scope of the instructions of the program, Your Honor, as indicated in the record on appeal, that the flyer indicated parental consent, as counsel stated, for ages 12 to 17 was required. So the fact that they proceeded without that consent means that they moved beyond the instructions of the medical society, beyond the instructions of the school system. The other piece of this, Your Honor, is that we are dealing with a very specific context within the PrEP Act. This is not vaccines generally. It is not medical care generally. It is the provision of a covered countermeasure during a declaration of emergency under the PrEP Act.
Was this the type of behavior that was intended to be covered? Do you think Congress intended to remove any type of civil liability regardless of what the facts on the ground may have been?
No, Your Honor. I think the facts matter. And the facts that we have here today are not the parade of horribles that have been laid out in various briefs. The facts here are specifically, there was no alleged physical restraint, there was no alleged coercion, there was no alleged false pretenses or any of those.
How can you say there's no coercion when the child was 14 and the medical providers did this?
Again, coercion, Your Honor, in terms of forcing the child, no, the child was there as a 14-year-old and apparently signed a document, made a verbal statement. The clinic worker did not adhere to that statement. That clinic worker did something that they should not have done, and we acknowledge that in terms of what's alleged on the pleadings. This vaccine should not have been administered. That is not a question that we dispute. The issue here is that we do not have somebody being tackled. We do not have somebody being lied to. We have a situation in an emergency that Congress has foreseen that during a state of emergency, there are going to be mistakes made. And in terms of a national response to a national and in fact global pandemic, Congress recognized that there's going to be a public and private partnership across the board, across state lines, from researchers to manufacturers to deliveries to medical professionals and volunteers and site facilitators, all of whom have to be on the same page in order for that response nationally to be effective. If the truck drivers who are bringing the temperature-controlled vaccines across state lines from the manufacturing facility to the site can create liability for the trucking company because they didn't maintain that temperature, and therefore the trucking company says, we won't participate in this because of the risk of liability if these vaccines spoil in our truck, the whole chain falls apart. Everything from research to delivery stops.
But compliance with the state law here would have eliminated the issue, wouldn't it?
If there had been a parental consent here, we would have no issue. That's correct.
Right. So I'm struggling here because it's very difficult for me to accept the idea that what Congress meant, or that Congress meant to say no liability, even if a person doesn't consent, or even if in the case of a minor there's no parental consent. And so to go back to a question that I asked your opposing counsel, don't the examples of loss given in the PrEP Act signal to us that Congress didn't have in mind what you say it had in mind?
I don't think so, Your Honor, and here is why. First, I think the PrEP Act's plain text is extremely broad, and counsel has responded to that. But specific to this question on the use of including, because in that definition of loss, the definition is any type of loss. And then it goes on to list out a few examples. And what the United States Supreme Court has told us in Campbell v. Acuff Rose Music is that the statutory use of the word including is an illustrative and not limitative function. In that case, it was about fair use and the statute laying out examples of fair use, but not excluding others.
Well, I grant that it's illustrative and not exclusive, but it does it not tell us the kinds of things Congress had in mind?
Your Honor, it tells us some of the things that Congress was laying out as possibilities, but it does not exclude others. And then we can look at the scope provision, which immediately follows that definition, and says a loss is, the immunity under this paragraph applies to any claim for loss that has a causal relationship with the administration of a covered countermeasure. So the limiting principle here, and I think this goes to Chief Justice Newby's concern that there needs to be a limiting principle. The limiting principle is the causal relationship between the administration of the countermeasure and the claim. The claims you have before you today do not exist if the vaccine is not given. Therefore, they cannot be causally separated from the immunity that the PrEP Act provides. And that is what the Supreme Court of Wyoming has said, the Supreme Court of Nevada has said, the Kansas Court of Appeals has said. They understand this is not comfortable.
But would you agree, but would you agree that none of the examples that are given are anything like what's at issue here?
I would not grant that, Your Honor. I think that the MT versus Walmart in the Kansas Court of Appeals, there was specifically a battery claim, and there was specifically a fundamental parental right to consent to the vaccine claim. And what that court said was...
Well, I'm just looking at the text, so I'm wondering which of these examples you think is analogous to administering the vaccine without consent.
I'm sorry, I misunderstood your question.
I'm
The
just
statutory
looking the statutory
examples?
text, the examples, and I'm wondering which of those you think is analogous to administering the vaccination without consent.
I think the provision that is most closely analogous here, although I will not argue that the statute does not list out constitutional rights, fundamental rights, but a property right is one that is can be very broad and covers a lot of ground that Congress was saying all of these types of rights that may not fit specifically under a regular tort claim can flow from that.
Shouldn't we want to interpret this statute in a way that doesn't potentially bring it into conflict with fundamental constitutional rights?
Yes, Your Honor. I think that the fundamental, another of the bedrock principles of this court is constitutional avoidance. And you can do that here by finding that any of the other grounds that were available from the trial court's order are sufficient for this court.
Well, we didn't grant review on those. So doesn't it create the potential for big constitutional problems if we say that what Congress intended here was to say, or to protect from liability folks who are administering vaccines to minors without consent?
Your Honor, what Congress's intent appears to be from the statute's text is to reach as many of the pieces of the chain from researcher to administrator of the vaccine and ensure that in this rush to provide an emergency response, that an understanding that there are going to be mistakes made. And one of those mistakes is proceeding too quickly to give a vaccine, either because a minor gave their consent when they weren't legally allowed to, which is the Kansas Court of Appeals case.
Is mistake the right word for the, and it's, it's an allegation, but is mistake the right word for the alleged conduct?
Yes, Your Honor. Error in judgment may be another way to put it. But the issue here is if one administrator of a vaccine errs in providing a vaccine when they should not have, and we, again, concede that on the pleadings, this vaccine should not have been given. But if that one person creates now liability for the medical society, the school system, or whomever is hosting a vaccine clinic, that chain that Congress was intending to set out for a national comprehensive response to an emergency falls apart, because those institutions will now withdraw and say, if one of our people steps out of bounds, we are going to hold this liability. And Congress, I think pretty clearly from the broad language that's available in the statute, was saying we recognize that there are going to be errors in a pandemic response. There are going to be things that get rushed and balls that get dropped. And we are not going to shut down the system because of those. We are going to immunize against those, and we're going to provide a compensation fund for the most serious of injuries that come out of that.
Sorry, I will let you go after this one. But going back to the examples of loss, if what Congress meant was truly any kind of injury, constitutional, whatever, it seems to me that you'd have at least some examples in that list that aren't really tort-based. If what you wanted to signal was that the immunity goes beyond sort of traditional tort claims, how do you respond to that?
I would respond by pointing to the breadth of the language that surrounds that list. That list is not all-encompassing. It was not intended to be all-encompassing. As I said, it's not limitative. But what we have in the provision just before that statute is that a covered person shall be immune from suit and liability under federal and state law with respect to all claims for loss caused by, arising out of, relating to, or resulting from the administration of the covered countermeasure. And immediately after that provision, we have that the immunity under paragraph 1 applies to any claim for loss that has a causal relationship here. So again, Congress was surrounding that listing. These are examples. These are probably the most common examples. When a vaccine is administered, we are concerned about side effects. We are concerned about design defects. We are concerned about allergic reactions. We are concerned about dosage mistakes, labeling mistakes. They cannot list all of those things out, but they gave a number of broad examples, everything from physical injury to emotional injury to property and business injury. That's a broad list. It is intended to illustrate that Congress could not anticipate every version of liability that could arise. But in the context of the plain text around it that is discussing the breadth of these claims, it seems clear that Congress was recognizing its own inability to foresee every possible outcome and immunizing.
Justice Allen's question to be that, I mean, typically, because it reads like a definitional section, because it says, this word means this. And you would expect, typically when that happens, that when you say this word means something, that you're not just going to redefine it again as that word, because that doesn't help you really understand it. And so, to say an apple is any type of apple, it doesn't really help you know, but what is an apple? And so I understand Justice Allen to be saying it seems like what Congress was doing then is saying loss means any type of loss, including these things that you can then use textually, that list of things, to help understand what loss must mean. And that the harm here is so far outside what's on that list that it must not be included within the scope of what Congress defined a loss as here.
The list, Justice Deeds, as laid out by Congress is, I think, quite varied. And that goes to, as you said, an apple is any type of apple, and then you can list out 7 different types of apples. But if you leave a gala apple off of there, that doesn't mean a gala apple doesn't fall in there. And a crab apple may be very different. I'm going too far with this metaphor. The question is, are these limitative examples, or are they indicating Congress's attempt to cover as many types of loss as possible and recognizing in the context of the language that there may be others? And that is what other courts of appeals and Supreme Courts have found, is that when you look at claims around information that was given about the vaccine, or whether the particular vaccine was on the consent form, that's the Wyoming Supreme Court in Byrd v. State. A 15-year-old, he wasn't quite 16, so he couldn't consent, and they gave him the vaccine anyway, and the parent sued, again, under their fundamental constitutional right to control the upbringing of their child. And the Kansas Court of Appeals agreed with the statement that all claims for loss means all claims for loss, not all claims for loss except for these specific fundamental constitutional rights that look a lot like, they are very similar, right? The parental constitutional right issue here arises out of the battery. It arises out of the unconsented to touching. They're all the same central facts here.
But even for the battery, the kind of common law dignitary harm that comes from a battery is different from what's in the list of descriptions of loss that Congress laid out. Those are things that, sort of stem from, that are called, these property damage or any of these sort of tort injuries are, you think of it as having some cause, whereas with the dignitary harm for the battery, it's really something different that happens before. In fact, the battery could occur even if you, sort of, I'm going to give you the vaccine, grabbed your arm, and then didn't actually vaccinate you. So to me, it seems, I liked where you cut your hypothetical short, but I liked where you're headed, which is, what about a crab apple or, the apple of the sea type thing, and say, well, but those things are so different from the list of traditional apples that maybe you'd say this probably isn't covered, even though it has a similar, you might sort of give it a similar name. Why? Because we know from the list you mean sort of traditional apples. And I think that was Justice Allen's point, is these seem like traditional tort injuries And what's alleged here is not, that would result from being administered a COVID vaccine, and this isn't that.
Yes, Your Honor, and I think the crux of that issue is the causal relationship, that this court can draw a line around it but for causation. You can interpret this statute to create an immunity for something that is causally inseparable from the claim and the action here, without getting into the outer limits of the statute. So the tort here, or the constitutional claim, the battery claim, only exists because the vaccine was administered. If the plaintiff had been tackled to the ground and they'd been about to administer the vaccination and someone had stopped them, the battery claim still exists, even though the vaccine was not administered. And at that point, immunity would not apply. Right? That is an independent battery. I think the example I used in the brief was the vaccine strike team breaking through to try to take these absurdities to their fullest, breaking through the windows and vaccinating people in their sleep. No, of course that would not fall under the PrEP Act immunity. But you don't need to decide that today. All you need to decide today is, does the administration of the vaccine, the actual administration of an actual vaccine without consent, fall within the ambit of the PrEP Act's immunity provisions? And every appellate court in the country that has reviewed that specific question has said, yes, it does. And the Court of Appeals, I think, was on point when it said, wisely or not, this is what the PrEP Act says. And Congress gets to decide what the PrEP Act says. And the plain text of the PrEP Act includes claims for failure to get consent that arise out of the administration of the actual countermeasure here. The but-for test, I think, binds the different cases that we see from around the country. In the Vermont Supreme Court, Palatella was looking at battery and a state constitutional claim. And in that case said, no, these claims arise from the administration of the vaccine. Therefore, they are within the ambit of the PrEP Act. The Nevada Supreme Court in DeBecker was looking at a change in treatment from somebody who was self-administering ivermectin and ended up in the hospital, and they immediately started administering remdesivir. And a suit came based on failure to consent, and they said, no, the covered countermeasure here is remdesivir. It was actually administered, albeit without consent. But that is a claim for loss that causally arises out of the administration of the covered countermeasure. The point of the PrEP Act is to give our medical personnel, our manufacturing personnel, our distribution personnel the confidence to do their work quickly but as effectively as they can, recognizing that if there are missteps, if there are errors in judgment that are causally directly related to the purpose of the PrEP Act, that they and their employers and the institutions that are all joining in this chain to address a national emergency are not going to break down under the threat of liability that those cases present. Now, in terms of the argument around preemption, I think I will start by saying you don't have to decide that. Again, that this is a case the court can decide narrowly in a number of ways. As Justice Allen said, you did not grant discretionary review on the other grounds, but this court has in the past granted discretionary review to address a specific constitutional question and then turned and decided the case on more narrow 12b6 grounds. A couple of examples of that are Ladd v. Estate of Kellenbarger, the North Carolina Parole Commission, Collins versus the North Carolina Parole Commission, both cases where the court specifically took an issue that was controversial to address it for the state as a whole, and then after hearing it, wrote an opinion deciding the case, not remanding, deciding the case on narrower grounds that did not address the specific issue that discretionary review was given on. So this court could choose to do that again today. There are issues on the face of the complaint that allow that. But even if this court is going to reach the PrEP Act, you do not have to discuss preemption. You don't have to reach these issues of federal and state sovereign powers. You can just look independently at the immunity provision and say this immunity provision is intentionally broad by Congress. We don't have to decide the outer limits of it, but this clearly falls within it. But if you were to reach the preemption question, what Congress has done again is make clear its intent, which is that the institutions, that are participating in this national response need to be protected from liability. So during the effective period of declaration, no state or political subdivision of the state may establish, enforce, or continue into effect, with respect to a covered countermeasure, any provision of law or legal requirement that is different from or in conflict with any requirement applicable under this section. And the idea of a legal requirement captures common law claims for liability as well as any regulatory response by the state. The preemption connects with the immunity provision here, in particular, when you look at another example of how broad the immunity is intended to be, which is in section D1, where Congress states that the sole exception to the immunity from suit and liability of covered persons shall be for an exclusive federal cause of action for death or serious physical injury proximately caused by willful misconduct. So again, if you go just piece by piece by piece, the statute is laying out a very broad immunity and then stating specifically the sole exception is death or serious injury caused by willful misconduct. And then you go to the preemption provision, which specifically lays out, and Congress knows what these words mean because the Supreme Court has told it so, that if it says legal requirements, that includes common law claims. So they are clearly including common law claims within the preemption. And if this court were to impose liability or allow the imposition of liability here, it would be going against not just the immunity provision, but Congress's intent that states not enforce common law claims against those who are otherwise protected by the PREP Act. I do want to return just briefly to context here. And I appreciate the careful and thoughtful questions that the court has presented, because there was some hyperbolic language that came out of some of the briefs in this argument. But this is the action of one person who overstepped. The school system, the medical society had a consent requirement. This is not a case of a school system running amok, locking kindergartners in a cafeteria and administering vaccines.
Well, given your reading of the PREP Act, does that matter? I mean, suppose that the society instructed its folks to administer the vaccination, regardless of consent, because of, belief that the pandemic was so dangerous that that action was warranted. Would there be immunity in that scenario under your reading?
There would be immunity, Your Honor, for specifics around that are directly caused by the vaccination. If someone is brought in and falsely imprisoned for the purposes of it, that would fall outside. If someone is tackled and administered a vaccine that they were trying to run from, that would not be covered. But if someone has an allergic reaction to the vaccine, yes, that would be covered. That's causally related to the administration of the vaccine. But there are other avenues here for addressing some concerns.
Then aren't you, I realize you're inviting us to cabin our ruling in based on these specific facts, but aren't you in effect then saying, well, Congress intended to allow organizations like the society to go out and administer the vaccine without any consent whatsoever and face no civil liability?
No, Your Honor, I don't agree with that, and that goes back to Mr. Walker provided the court with a quotation from the Food and Drug Administration Act that consent is a requirement for the emergency use authorization. Congress is working with these statutes in concert, and clearly consent is an expectation of Congress. What our argument today is not that we can have broad programs that are designed specifically to evade that, but that Congress intended for errors in judgment in the rush to address a national emergency are intended to be protected. There is injunctive relief that can be provided, for example, in a case like yours, that if the medical society is trying to administer willy-nilly without regard for consent, clearly injunctive relief is available, and then contempt for defiance of that injunctive relief would be available. But this is not that case.
Would you agree that your interpretation of the PREP Act places local entities, local governmental units under some pressure to violate state law, state consent law here?
No, Your Honor, I don't agree with that. The intent of the General Assembly here is clear, and I think we noted in the brief that the coincidence of the timing of the new provision going into effect, that's not a legal issue before you today. But there is no question that the state of North Carolina expects that consent be received. And for anything other than an emergency use authorization, that can be given by the minor under 90-21.5. Under this specific new change to the statute that occurred an hour before this vaccine was administered, it is clearly the policy of North Carolina that for an emergency use authorization vaccine, parental consent is required. Well, we agree with that. The flyer in the record on appeal shows that the school system and the medical society agree with that. I don't think the PrEP Act, as you asked, is intended to put any pressure. I think the PrEP Act is intended to relieve pressure, that we don't have medical administrators, distribution networks, manufacturers who are paralyzed by fear of liability and therefore do not participate in this comprehensive national response to an emergency. And that undercuts Congress's intention in addressing that. Congress has to address this national emergency. Everyone has to get on board. And if people are afraid of liability for errors in judgment along the way by a single employee, they won't participate. And the whole chain falls apart. That is the purpose of the PrEP Act. That is why an error in judgment, like is alleged here, is covered by the immunity. This employee may or may not, it's not on the pleadings, may or may not face employment consequences. There may be licensing consequences, but there cannot be civil liability for this particular error in judgment. That is all this court has to decide today. We would ask you to join the Supreme Court of Wyoming, Nevada, Vermont, the Court of Appeals of Kansas, federal district courts in Oklahoma, Kentucky, all of whom have determined that the questions before this court today, even though those policy consequences are concerning, fall within Congress's intent in weighing the balance between those consequences and the need for a comprehensive national response to an emergency like a global pandemic. And we would ask you to affirm the Court of Appeals. Thank you.
Counsel? Rebuttal?
Just a few quick points in rebuttal. We're assuming from the pleadings that this was just a couple rogue workers. We don't really know that. This was a 12B6. We didn't get into discovery, what was discussed, how, what the plan was internal to the Old North State Medical Society. And so I would just say we don't know that it was just one person who was going rogue. We don't know that because of the posture of the case. It was dismissed at a 12B6 hearing before discovery had taken place. I think it's important. Congress listed some things out, and they all sound like tort claims, sound like personal injury claims. And if the idea is all claims, I don't think Congress needs to give certain kinds of claims, but not other kinds of claims. And I think that consent was a given, that consent was something that you were supposed to get before you do this. That's why in the emergency use authorization statute, it requires one of the conditions to be consent. And our General Assembly wanted to make sure that this didn't happen, and that's why they passed the law that they passed, to say you cannot be giving emergency use authorization treatments to minors without parental consent. I've heard it said that courts are not constrained by the bounds of common sense, but I believe this court is. I believe this court has been, and I believe this court will be. And for that reason, I ask you to make this case make sense and to reverse the decision of the Court of Appeals. Thank you.
Counsel? Thank you both. Mr. Clark?
Rise.